So, Dr. Arnold, a lot of times when people are talking about the Constitution in the news, with the Supreme Court, for example, the word originalism comes up a lot. What is that?
Originalism is the claim that the only way to interpret the Constitution is based on what the Founding Fathers thought at that time in that hot summer in Philadelphia. And it's, as a constitutional historian, as someone who cares about the history of the Constitution, about what it meant then, about what it meant in the 1820s, about what it meant in the Civil War, about what it meant during the Gilded Age, the concept of originalism is, to me, incredibly frustrating. I think judges use it as a shorthand. I think it does violence to the original idea of the Constitution itself. And I think it was Thomas Jefferson who didn't help to write the Constitution, but who was involved, especially as president, in trying to understand it in those first years when they were really just struggling to understand what it meant and struggling to put it into action. As Ben Franklin said when he was trying to convince all those framers to sign it, to make our thoughts unanimous, what he really said was, it doesn't matter so much what it says here. He understood that the Constitution was a brochure for this new idea of a national government. They left a lot of things unsaid. The word slavery doesn't appear again because it would have offended both sides. They left the question of the balance of power between state and national government aside because they knew they would have to solve it. But also, just in those first few years, they're still arguing about the meaning of the Constitution. George Washington famously says to Alexander Hamilton and to Thomas Jefferson, please explain the necessary and proper clause. The necessary and proper clause, Article 1, Section 8, it's the 18th clause. Article 1, Congress's powers. Article 1, Section 8, Clause 18. What does it mean? George Washington honestly asked that. And Alexander Hamilton and Thomas Jefferson came up with opposite answers. So, as the Supreme Court Justice, you get to say, well, which one do you want to go with? And also, if what you're saying is that you're going to rule on questions of equality and equality before the law and what it means, well, where are you going to stop the clock? Are you going to stop at about what they meant in 1787, or what they meant with in the whole assumptions around the Constitution? Are you going to stop the clock in 1868 when they passed the 14th Amendment and the words of John Bingham, who crafted the 14th Amendment and pushed it through Congress? Or are you going to stop the clock, as so many want to do, in 1905 when the Supreme Court said that the 14th Amendment, the right to equality before the law, only applies to liberty of contract? Judges can't get away without the duty to judge. Their judgment matters, and precedent is like the wake of a ship. You don't get to stop it and say, well, we're going to cut out this whole period. It never detaches from the ship. It never detaches from history. You can't stop history, and that, to me, is what originalism tries to do. It's a very long-winded way of saying, I think as a historian, originalism is a religion, and originalism is bunk. And it's a shortcut for judges to get away from the duty to judge.